Hi, everyone. It's Grant Abbott speaking, and welcome to this. I love this session. This is all about setting up wills and also living wills for your clients, whether you're an accountant or financial planner. So we've been developing this process for quite some time. A lot of our advisors have effectively been in the process of offering wills, even wills and testamentary trusts to their clients. So it's been a very exciting opportunity for everyone, and we see the way forward. And as Tony explained before we jumped on, to those people who were early, that we've got a position that in Melbourne, obviously COVID's a big issue, but we've got two stanzas there. Is we've got effectively the lead up to obviously dying, and really if you have a look at all the people in the nursing home, and I just went through with my mum and dad the issues around enduring powers of attorney, and if they're not up to date, it can be an absolute nightmare when it comes around to selling homes, etc. So we need to get in place enduring powers of attorney, advanced healthcare directives, enduring guardians, and something else will be popping up a little bit later on, probably in a month or two, is a SMSF binding living nomination. So a binding living nomination, so that the members of the fund can declare how their funds are to effectively be used in the event that they do become incapacitated. Otherwise, it's essentially left up to someone else. But there's a lot of issues around that. And if you haven't seen our videos around doing a will, doing an EPOA, doing a will with testamentary trust and EPOAs, then they're all sitting up on the Strategy Centre. But today we want to go through the legal side of things, and more importantly, focus in on the task at hand. And really, my point, and I'm sure Tony can chime in here, but I look forever and forever and a day that I've known, particularly around self-managed super funds, but accountants and planners have been extremely frustrated with clients when it comes around to estate planning. And really, at the end of the day, we as professionals are really bound by the know your client rule, but it just doesn't seem to apply to lawyers because it's just a simple transaction basis. There's a referral by an accountant or planner to the lawyer. The lawyer will get a bit of information and then they'll draft it up on a precedent. So that's normally what happens. You just want to go through what typically happens in a suburban lawyer's practice, why it takes so long, etc. Tony?
Yeah, it's just, I've been through this process, many times before, working for, for legal firms and that. And, client comes in, it's been referred either by a planner or an accountant, client gets referred. We sit down with the client, we take all the instructions basically, like no different than a data capture sheet. We prepare all that. That's the pre-drafting stage of it. And then once, it may take, probably around about an hour and a half to go through the process of that interview sheet. And then we send the client away. In between that, we come back, we start drafting the document, or the documents rather, and we send them off to the client. The client, usually responds, I don't know, from experience, 2-3 days later. And then we do the amendments, and then we get the client back in there again. We get another set of instructions.
It's never ending.
The process, it's a never ending story, mate. It's just, it's just unbelievable.
I know, especially if you don't know the client rule, and I've seen some of the data captures or the interview processes that, because effectively what happens is the lawyer will sit down, he's got a Word document that they'll give to the client, or they'll fill in with the client, and it can go for up to 8 or 9 pages. And it's so ridiculous. I've been through a couple, and I must admit I've even been through a couple of online wills, ones that have been released here in Australia and all overseas. And I tell you what, they're so difficult to understand. And this is where the opportunity is, I believe, well, not believe, I know from the people who are very successful, that in effect the know your client, particularly with accountants and planners, you already have all that information sitting at your fingertips, and the data capture that the client needs to go through really isn't isn't a big deal. It's more about getting that succession right. You know, who's going to be the executor, who's going to be the enduring power of attorney, what rights and entitlements are they going to have if they're sick or they're incapacitated, who's the next, and then who's the next. Because once we get that succession, then we're pretty well right. And then it's a matter of just going through on how the estate is split up, and more importantly, how the super fund is split up. And for those of you who know, our methodology is we keep super away from the estate, because obviously with family provisions claims, and now you can even see, I saw someone from Dan Butler's office yesterday saying that if you're transferring super money into an estate for a testamentary trust, aka super proceeds trust, effectively you must get a binding ruling from the commissioner that it doesn't breach the new testamentary trust laws. Now, we don't worry about that sort of stuff anyway inside our methodology, and that's we've been teaching you guys, is that it's better to come straight out of the estate, and then the trustee of the, not go into the estate, come straight out of the SMSF, because the trustee of the SMSF can actually, at law, set up a testamentary trust, which we call an SMSF Death Benefits Trust, and that's covered so that if, for example, we've got a young family and they've got children, dad dies, and we've got money in superannuation that can be passed out to an SMSF Death Benefits Trust, and effectively any income coming out that would the children or the dependents would be taxed at their ordinary marginal tax rates. So it's a much better system than what we're looking at now. And of course, the beautiful thing about our system is that Tony and I have developed quite a comprehensive wills basis, and for the start, I would say that are we 100% perfect? Well, that's impossible at all with any law. We can even go to some of the big lawyers and get $40,000 or $50,000 estates, which I've seen. But at the end of the day, is it perfect? Absolutely not. So the law changes, everything's changing, and we're continuously developing our system. In fact, after this, we've got a session with 2 or 3 of our big advisors to actually go through the data capture, so that the data capture that you provide, which I believe is really meaningful anyway on the site, that we continue want to improve that. And then you'll come back to us with ideas and concepts and strategies, and we can build on that. In order to make this the best system ever, which I think is absolutely crucial. But it puts it in your hands rather than in the estate planning lawyers, which means you can move things pretty quickly. So do you just want to go through? So this is from a letter of advice that you did, Tony, which is available for anyone who's a Lightyear Docs user, as to how it all stands with the Legal Professions Act, and more importantly, what is legal services and what is not legal services, so that we're not only just covering wills, which we'll look at a little bit later on, but more importantly, we're looking at all docs on any online service for that matter.
Yeah, absolutely. Look, at the end of the day, you guys as advisors are preparing the data capture sheet. And what you're just inserting is inserting fields as per the questionnaire on the platform. So legal advice is drafting documents, giving legal advice, well, obviously appearing in court, of course, and using the name of a solicitor, basically, or a solicitor's name, or business name, and the name used to describe someone who's qualified to engage legal practice, basically. So you can't, in other words, you can't, right? You can't redo the document, basically, and start drafting or change the document as it is, basically, as per the document. Sorry, mate, I can't hear you. That's why.
Yeah, is that okay? It's everything's fine. So I think the main thing is that with the document process is that it's all hard coded into our system. So it
Yeah,
means that effectively you're doing the data capture, or you're inserting the administrative details, much the same as a clerk would do in a
yeah,
legal firm, that effectively they're not preparing it. What
yeah.
they're doing is they're merely doing the administrative side of it, which is pretty important.
So you just can't get in there and basically start changing the document because um, that's a form. Basically, what you're doing is you're 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 drafting now. You're in the process of drafting a legal document now. So
Yeah.
you can't do that. Um,
So I think
so pe-
that's pretty. I think that's pretty important. Is that essentially there's been a couple of cases whereby the Legal Professions Act has been ensued. In fact, there was a Western Australian case many years ago, probably about 30 years ago, whereby someone set up a legal drafting business for wills, and then they were going out to franchise that across Australia. It was held that essentially they were drafting the documents up from scratch. Whereas here we've actually got the whole system and the whole precedent base there. In fact, if you've seen the obviously the Light Doc system, there's an interview which then leads directly into that legal form, which is pretty crucial. So
Mhm.
that when we go down that track, there's a two-stage process there. And the first one is that if you've got a basic will and you're doing it for yourself or your staff, or even for clients from a very, very basic perspective, the legal process there has been basically delivered into the system. And so that's just, well, who's the executor, who's going to get a certain percentage of the estate, so on and so forth. EPOAs, again, they're all just state-based EPOAs. So the forms we have on the site are directly taken off the various state offices around Australia. So we're using that. So you're plugging directly into that, and I think that's absolutely crucial to ensure that you're not providing that service. So that's for the basic wills, but you'll see when we get around, and when you do your will, and I'll show you what the package looks like very shortly. Is that when you do that, there's the second option is that inside the letter of sign-off from Abbott Mourly, that's from Tony. The first one is that essentially the document has been prepared from a data capture and is not to be considered legal advice. And it goes through with the client, whether it's a will or it's a will with an EPOA, for them to check it very carefully. But it comes with a caveat, which is also really important for you, that legal letter of a sign-off, is that, look, if there any of these issues are raised, and I'll go through the issues and then I'll come back to Tony and he can talk through it, but any of these issues are raised by your client, and again, it's a know your client basis. Most of you should be well aware of the client's position, but we're just simply getting to reaffirm it. If there is, then we may need to go down the track of doing something a bit more specialised, which then leads into the Abbott and Mourly roadmap, which we'll look at. So some of the issues there we're looking at is, are you getting married in the near future? Obviously, that's going to have a significant impact on the estate. Are you separated but not yet divorced from your spouse, or do you have an ex-spouse? Particularly around most states in Australia, you'll find that eligible persons, as defined under the various succession acts, particularly around a family provisions claim, includes spouses, dependents, children, even includes ex-spouses. So that if there's an issue of an ex-spouse, then we need to have a really good look at what we're doing in terms of the estate. And to be brutally honest, Tony and I have done probably the last maybe 4 or 5 months, we've done a lot where there's been ex-spouses. And then we end up, if there's a potential issue in the estate, that what we do is we end up just doing a basic will and EPOA, or in some cases, we've just done a codicil for an existing will. And then what we've done is a protector and placed most of the equity of the individual into a family protection trust, so that family provisions claim doesn't raise its head. So again, do you wish to exclude any close family members such as a spouse, partner and child? Again, that's a family provisions issue, and we can draft up something absolutely super brilliant when it comes around to testamentary trust, etc. But at the end of the day, those clients effectively can, or those individuals can make a claim against the estate under family provisions. And don't worry, there's plenty of lawyers around who are happy to take that on. Do any of your beneficiaries have special needs, including mental or physical incapacity, marital problems, bankruptcy, or a big spender? So again, the testamentary trust is important. And also, don't forget that the special disability trusts, which are available from Abbott Mourly, are really a good suggestion on that level, because you can directly place money from an estate into a special disability trust. And that's not impacted from Centrelink, which is one of the only cases to be able to do that. Obviously, if you've got shares in a family company or somewhere, what's going to happen with that? Who's actually going to keep on running the business, which is, again, is pretty important. If you've got beneficiaries living overseas, is quite an issue. So all of those ones, once they raise their head, then there needs to be a bit more of a deep diving, and that's where obviously Abbott Mourly get involved. Is that right, Tony?
Absolutely, yeah. So, so it's a, so at the end of the day, so what needs really to happen is data capture. After the data capture has come, it's, basically spits out the will as it is, and then it comes up to us, and we review it, and which we'll get into later on, basically. And if there's any tweaks that we need to make, we'll make them there and then, basically. So the process, the process takes a couple of drafts at the end of the day, and that should be it. And this is, well, here you go.
What I'll do is I'll come back to the roadmap.
All right,
let's go and show exactly where we're going in terms of where we find the data capture. So go up to Lightyear at anyone. You guys are going to be logged in. In order to log in, when you log in, you'll find the strategy center. That's not available to anyone unless they're actually logged into the site. So there's a lot of IP sitting in there.
Mm-hmm.
So you're going to find that this webinar will find its way into the webinar videos later this afternoon. So I'll put that up there with obviously the slides as well. So what we've got there is we can go and have a look at some of the client tools, which are really important. Over on the estate plan, you can see there's the protector one. And I think that if you have got a client that says yes, or a lot of those issues that are really important, you need to have a chat with Tony and I at first instance. And the best way to contact Tony is just through his email, which is abbott.mourly.com.au. And then we can work out whether it should be, is it better to have most of the wealth stored up in the protector, or should we do it by way of testamentary trusts? And that's an issue for the clients themselves, because there's potentially going to be a difference in your costs rather than our costs, which is pretty crucial. So when we have a look at the data capture, so what we've got here is this is just, you can download this. In fact, you can just email this off to the client. You can see there we've got a Word document, and Tony's working with a couple of people later on this afternoon. There's that letter I was talking about from Tony in terms of provision of legal advice. So that's available again if you want to have a chat with, if you want to go off to Anamourlis at Abbott-Mourly.com, and he'll provide that for you. Here you can see we've got a client will and enduring power of attorney letter. So this is something to send out to your clients to start off with. I was hoping we had both Tim and also Kush onto our system, but it looks as though something may well have happened to those guys. So I'm not sure. You never know these days. Things are getting pretty busy, but more importantly, obviously everything's a bit of a melting pot at the moment, because I know Kush is out in one of those affected areas. So in Sydney. So this is a simple letter we've got there. And look, it's really to point. And in fact, Tony probably nutted out this morning, the first line, the coronavirus having an impact on society. Many of our clients, Australians for that matter, people across the globe are concerned for their own safety and that of their family. I can tell you there's a big grip up here in Queensland from those two crazy girls from Logan who went down through Sydney to Melbourne to do a big shop, or I shouldn't say a shopping trip, they actually a shoplifting trip, and then came back to Queensland, and there's been a few, they came back with COVID. So that's an interesting position for them. But look, we're asking ourselves a whole range of questions, including what happens if I wanted my family. So have a look at that. Have a look at that particular email that you can send up. Just simply send it up. And then we go through and look and really encourage your clients to go and draft up a brand new will. And certainly an enduring power of attorney. Ours is completely different to everyone else because it looks at both existing directorships you may have, existing companies to continue the business, and more importantly, what happens in the event that you do become incapacitated, who's going to run that self-managed super fund. So ours is the only EPO in Australia that has that. In fact, it's the only one in the world that has that. So we've thought a lot about that. Now, again, we go through the process. So the process is simple and effectively, if you get your EPO and executors right, it goes through that. Building a line of EPOAs and executors is really important. And as you can see, that going back to what Tony's saying is a lot of this advice is coming from Abbott and Mourly lawyers rather than you. So that's really important because we see ourselves as partners in your business. We're not there for you to refer directly. We do have some accountants that send clients our way, but we'd rather be in that process of working with you and going through that, which Tony's going to go through the process very shortly. So this is the letter that goes out, 3-step process, complete the quick data capture attached. You guys will review it, make sure it's tax efficient, covers all the bases, etc. And then if need be, we then have a meeting with Abbott Mourly to go through. As I said, we'll go through that 5-step process that Tony's talking about. You can put your pricing up front. There's a suggested pricing schedule, which is sitting in the, again, in that client tools area of our strategy bank. Or alternatively, just get the clients to come in. And what I would suggest there is that if you're doing one, you'll find our EPOA and will package. You can do it for husband and wife. So they're not necessarily mirror wills. Mirror wills can be quite dangerous if they both die together and like you've got money going from one to another. It just doesn't make sense. You end up being an intestate. And look, if you end up having to go to the Supreme Court or you die intestate, it can cost at least, $40,000 or $50,000 just to get the issues resolved, or worse, you end up the public trustee steps in, and then that's when the nightmare starts. So what we've got is a simple data capture there. Who's to be your enduring power of attorney executor? We're getting then the line, if they're sick, who's the next one? If they're sick, who's the next one? Because generally we believe that the person who is your enduring power of attorney is probably the person going to be executor. Now, you must ensure that your executor is strong of mind, strong of fortitude, because essentially what happens there is if it's subject to a family provisions claim, it can be a big issue there for them. So you've got to be a really careful one on that. So if we have a look at that one, we've got our line of succession executors, etc. Then we go into our enduring powers of attorney, which are crucial. So this is just simply, is there specific guidance that they want or limitations, etc. And then we go into actually what the will is. So what are the specific gifts? So it's absolutely crucial there is that, if you want to give 50% of your super estate, do it by way of a specific gift. If you want to give a property, do it by way of a specific gift. If they want to give jewellery and personal effects to one of their kids or all of their kids, or for the executor to determine, then send it by way of a specific bequest. And then essentially what's left over, then, who's the person who's going to take that, or persons? And if they're not alive, who's the person? So, from those data capture, we end up, you should get quite a substantial amount of information there, which is pretty useful. So that's our data capture. As I said, we're looking at improving it, but from the data captures and the interview processes, which essentially are built into the system themselves, we don't want to go and give it too huge a data capture. Otherwise, you'll end up, it just becomes too hard for the client. We just want to, what's that line of succession? And then what are the specific gifts? And if there's anything left over, who essentially gets that, which is absolutely crucial. So from that point, we end up going back to the estate planning side. I know you just, oh, there we go. So there's, okay. Hi, Tim. How are you? Sorry.
Hey, Tim.
Obviously, we're just going through the process for Abbott Mourly, and then we'll flip on to you very shortly, Tim. So that'll be a great one. So let's just go through. So that 5-step process, do you want to just go through, Tony, what for those ones who want to go down the second choice? So it's not a basic will. You know, we've got a bit of stuff here, we've got a bit of stuff there. You just want to go through that estate planning roadmap for advisors.
Yeah. So what is it? Let me just, there we go. We've got Khush coming online too, mate.
Okay, cool.
Cool. All right. So pretty simple. This is the roadmap that you should be working off in terms of the steps. And it's pretty easy to follow. What you're doing first is step 1 is preparing the data capture sheet. So what effectively happens is the advisor collects all of the information from the client, then inputs that information into the Light Year Standing platform. We then send out our cost agreements prepared and any other auxiliary documents to that. Okay, so that's the first step. Okay, getting all the intelligence together, all the info. Okay, which will make our life much more easy and simpler. And step 2 comes on. Then what happens is the LY. Once the data has been inputted into the Light Year estate planning platform, and then what it does is, once you finish it, it generates the estate planning documents. Okay, and it produces. It depends what the client wants, of course, and then it produces, for example, the will. It produces the enduring power of attorney, and any other planning documents as required by the client. Okay. Step 3 then goes on to do basically that the estate planning documents are then reviewed by us. So effectively, once the documents have been prepared and LY generates those documents, it's then up to the advisor or to send out a copy of those documents to us, so that way we can review those documents to see, exactly what's being done. And then we go on and do a Zoom with the advisor and the client. Okay, this may take 45 to 60 minutes, basically. Okay, so the advisor arranges the Zoom. We obtain any final instructions relating to the amendments to the documents, and then those documents are sent back to the client and its advisor for final review, basically. There will be tweaks in it, no doubt. It'll take, like I said, probably around about 1 to 2 drafts to get it right. And then step 5 is the AM finalises the documents. Documents are sent back to the advisor, and then we set up another Zoom, which is then arranged for the signing and witnessing of those documents, basically. And then what happens after we've witnessed those documents, they come back to me, I finalise them, I then make 2 certified copies plus the originals go back to the advisor, and we keep a copy as storage. The advisor keeps a copy, and then the advisor or us or whoever, we then send the originals back to the client for storage also. And that completes basically the 5-step process, in relation to the roadmap. So it's pretty simple. It's not, it's not that difficult if you follow the steps.
It's not it's not overly time consuming, because effectively you as an accountant or financial planner are essentially doing all the work really at the end of the day. So that when we come in, the main one there is you're preparing everything from the data capture, etc., so that when we go down the track of getting that step 4, that first meeting, and generally, although we've got 45 to 60 minutes, to be absolutely brutal, we find that it usually goes for only around about 30 minutes. And then there's the other 30 minutes sign-off time, because you know your client, you've got it all down pat. We look at the stuff and then it goes on. Because a lot of the grunt work is being done by you as the advisor, either the accountant or the planner, is that legal sign-off. Effectively, what we've got there is you're basically doing the grunt work, and I think that's important because it means there's less back end, and we know what the back end is. So there's a fixed fee for that. So typically, if it's a client with a testamentary trust and an EPOA, that whole process just for one individual, what would be the cost, Tony?
Because the cost will be, look, if we get a standard will, right, with this process, a will with an EPOA, it's $440 basically per will.
Okay, so that's pretty good. So for the EPOA and the will, it's $440, which is pretty good. So
it's pretty good.
Yeah, it's fantastic. So if you have a look at that, and then if it's husband and wife, then I think it's what, $840 or something like that.
Yeah, whatever it is, basically works out per individual, basically. So you're getting a good. It's a good price, because I know for a fact at the end of the day, you go out there, you do 2 sets of wills and 2 sets of EPOAs, you'll be paying, I don't know, probably around about $1,200 for it. So
that's per person, so 2.5, which is essentially what the advisors should be doing in that process. Is that's effectively the pricing that you should be looking to. And remember, this is a partnership with Abbott Mourly, so that at the end of the day, this process is a bit different. If I can then flick it back here. Basic wills and EPOAs, as I said, if it's a really basic one, just do that in-house. Typically, if you're doing a will and EPOA, charge anywhere between $800 to $1,000 for that. But when you go into choice 2, what you're doing is effectively that is being prepared, and this is the important thing. The process that Tony has taken you through in this 5-step process for you. This now is being signed off by Abbott Mourly, so now it comes under our professional indemnity insurance.
That's what happens in ship.
Yeah, so that is absolutely crucial for you as advisors. And I think I've got one here that I prepared before I hand over to Tim very shortly, and then also Khush. I looked at, I just pulled down one here that we've got, which is this, they go, oops, just a little bit big there. So I'm just getting ready for your spectacles, Tony.
Wow.
So if you have a look, this is the PDF that pops out. Let me just go down a little bit further. There we go. So if you have a look, this is the letter. Remember I said that this is the letter that's automatically produced. There's 2 letters as part of our kit, and hats off to Tim Munro, who has helped us prepare that or given us suggestions. So here's one for the will and EPOA. If you're just getting a will, then it's separate. But really, if you're going down this process, you want to do a will and an EPOA. So we talk about the attached will is based on the data capture, and this comes from Abbott Mourly to your client. And it's, again, it is important that you read the following. Is of legal nature and extends beyond the data capture, administrative processing completed by financial planners, Chartreuse Wealth. We're not solicitors, do not hold themselves out as such, which is what Tony said right up front. However, your advisors are expert in estate planning matters, including taxation, asset protection, succession, and ensuring where required the estate is limited to deceased bloodline or lineage. And of course, you've got the documents that are attached, and we talk about there, or we'll talk about what's included in the enduring power of attorney, what's included in the will. But then we go through, remember, these are all those questions, and just putting the client on notice. If there's any of these, then we've got to be careful. And then there's the second letter, which is important, which is the execution. Now, generally, that execution letter, that would be done, if you're going down that second process where you've got Tony, that would all be done in front of Tony. Is that correct?
Correct, absolutely. It gets done in front of me. We've done heaps of these in the past months now, and we just jump on Zoom. The advisor's with me, the client's with me. We take the client through the journey at the end of the day with the signing, and if anything needs to be amended, we just amend the document there and then. And then if an EPOA needs to be signed off by a solicitor, such as myself, we sign off, I sign it off in front of me. The documents are then sent back to me. I sign it on the day that I did the Zoom with the client. And then all the documents are sent back to the advisor, basically. And that's the process that I take. This is all subject to, but as part of the opening of a file, in any case, what I do need, and I always say that, is 3 forms of ID, so that way I can identify the client and I'm comfortable with it.
And also,
sorry.
And also, all of you must ensure that you get a mental capacity certificate before doing any of this sort of sign off.
Yeah. So it's important. The medical capacity certificate is important, especially, when I'm dealing with clients that are over, 70, 80 years old, basically, So I have to be satisfied as a lawyer at the end of the day that the client has got mental capacity at the, when I'm advising him about his will and his EPOA, he's got the capacity to understand what he's signing off at the end of the day. So,
okay, so we've got a good question. We've got a question there from Nino. I think it's important is that if we go back here, he's talking about what's the pricing for the advisor. Well, you'll see up on the, if I just go up again and go into our little strategy center, if I've got it around, and I go back here. So remember, you can get off this straight away, Nino. You can get up and have a look at the strategy center. You'll see here there's a client price list. And this price list is, although it's from us if we go directly, it's also a recommended retail price for you to charge your clients. You can see there, it's $2,600 for 2 mirror wills, or $1,850. Now that is what you charge, but then when we come back here, there's a fee payable to Abbott Mourly of that, as I said, was it $850 or whatever the pricing is. So again, just have a chat with Tony around that one. I think that's absolutely crucial. So that's where the value is for your process. Take that into account when you do charge. Obviously, you're not going to charge $500 or give it away unless you can absolutely ensure that you can recover that. So what I'll do is I'll just hand over. Tim, are you there at all? Or?
Yeah, Grant, I'm here. Hi, how are you? Hi, Tony, how are you?
Hey, Tim.
Good to see you both. Good to see everyone else here today as well.
Okay,
Yeah.
so just want to go through. So obviously you're using a lot of the stuff and you're more at that front end of us and we're more at that back end, devising the system, signing off. The 4 questions that I've got there is, how do you engage with the clients? What's your pricing mechanism? What's your process? And also, where do you see yourself going in 2021 with this, particularly with all the COVID going around? Must be very front of the clients' minds.
Yeah, look, as everyone knows, I'm the founder of Change GPS. So in Change Accountants and Advisors, what we're creating, we put into Change GPS for its members. And so we trial a lot of stuff and make certain that it works. And one thing I've been doing over the last couple of years is the estate planning and asset protection has always fascinated me, because accountants typically bang on about tax planning all the time. But unless you get the protection right, you could have assets of millions of dollars and you might be trying to save $5,000 in tax. But what about saving a couple of $1 million worth of assets? And I think that's where accountants need to take a step back and see the bigger picture, because this is the sort of stuff that clients really want. Now, even a smaller client, you might say, I've only got, my client base is a whole lot of mums and dads and they're individuals. But most mum and dad would have at least $500,000 to $1 million worth of life cover. So that means that if both of them to die, you might be looking at $1 to $2 million in the estate, plus maybe $500,000 equity in a home or whatever it might be. That's a substantial amount. And if you've got kids, it needs to be put in the right spot. So doing financial planning, I'm finding clients who come to us, 98% don't have wills. And in our statements of advice, every dealer group makes you write, you need to see a lawyer about getting your will done. So we put that in there. And how many go and see their lawyer? None.
Mm.
It's too hard.
Yeah.
It's too hard. They don't know a lawyer. People don't like going to someone they don't know. And so I've always passionately believed, just like Barry Lambert always said, accountants are the natural advisors about wealth matters, obviously accounting, but I believe estate planning and asset protection. So we can't do what you and Tony do. We can't, amend the documents or come up with the documents. But what you've given me is a framework I can use so I can have the conversations with my clients and help them to see the importance of it. So the way we do that is we've used a method called VPP, which stands for value, plan and price. So if I talk to a client, if I say, hey, listen, we can do this for you, it's going to cost $2 or $3 grand, the client will say, I'll come back to you. But if we say, hey, listen, if we articulate the value and then the plan to do it and then the price, virtually every single time the client goes, yes, I'll do it. So if I say to a client, if it's a small client, I'll say, look, mum and dad, you've both got $500,000 worth of life cover. That's $1 million. You've got $250,000 in your house. If you both died, you got $1.25 million. You've got 3 kids. We're going to make certain that stays in your family bloodline and everything's going to be fine. And, the price to that would be, these wills, they cost $2.5 grand plus GST. And when you position it like that, it's like, yeah, where do I sign? Or like if you look at the, the cheap suburban ones, like, mirror wills, mum or dad, if you've got a business owner that kind of receives money if mum dies or if dad dies, it's the worst thing possible. So we position ourselves as doing something which looks at the big picture, looks at the proper asset protection as well as the estate planning. So we never have any problems with amounts. We'll say, look, if it's going to be your ones for your mum and dad, 2.5 plus GST, if we're going to do more complex ones, and as you guys know, we've got quite a few of those coming up that I'm getting you to sit in with clients on, might be 5 or 6 or 7 or whatever. So it just depends how much. And that comes down to more work for us, actually getting these lists of assets and liabilities, working out exactly whose name's everything in. And we're actually putting together a spreadsheet now showing like right now, but then after an event where the assets or liabilities might end up. And then, how things need to trigger off so clients can actually see that properly. And that process takes a little bit of time to go through, especially if there are a few assets or if you've got to work out what's the value of a business and things like that. So that's why we always charge a couple of grand for that, because I'm not going to do this for $40 an hour.
No. And look, I know you're also developing some pretty nifty tools up on Change GPS as well around this estate planning.
Yeah. Well, like you said, I see we're trying to put together the tools so accountants can confidently explain the beginnings of this to their clients and quote, and help the clients to instantly understand the value. When they do, they go straight on light year and they use your process that they showed before, and then it's kind of across from using the Change GPS engagement to you guys doing the rest. So what we're developing right now, and look, end of August and in September, as soon as we've got it ready that's there for GPS users, where you'll be able to say, right, it's here the individuals, and these are a couple of their things. So you kind of tick the sort of things that you'd need, and then bang, there's the letter of advice with the recommendations, pricing, and action plan done in no less than 5 minutes. So you can actually get these out nice and quickly. And it might be, look, we want to use a protector at the same time to protect some equity in a property. Or it might be a PPSR registration to protect a loan. Or it might be just a basic will with enduring power of attorney. So the document will go from anything up to 25 pages down to 2 or 3. And why it's a bit longer is we have some diagrams that almost take up an entire page. It's showing how like an SMSF death benefits trust might work, or why your strategies of having assets in family protection trusts rather than in the estate is so important. So all the things that you and Tony have been talking about, Grant, we've actually put together, and then this document, which then can be used by accountants to easily help their clients to understand the value of getting it right.
I think that's important. I mean, as we go down, I know the accounting profession is pretty, for the next 6 months, as you've said, is got a lot around the compliance, but obviously with all the COVID, probably I know I had a chat with Michael Jeffries. He's now well and truly in front of his clients. He's virtually well and truly in front for all his clients. So that there will be potentially time coming down the track for accountants to go in and do this know your client stuff.
Yeah, definitely. And the way to start that is, I've always found from a marketing point of view, helping clients to be aware. You're not going to do it on the first email. You've generally got to touch them 10, 11, 12 times before they do something. So I would be just using some of your marketing material that you've got and some that we'll put together soon as well, just for accountants to get it out to all your clients. Say, hey, listen, if your wills and powers of attorney aren't up to date, you could have a few issues, just a few bullet points, talk to us today. Now, send that out for 3 months in a row. And then in the fourth month, you'll start to have clients contacting you. And so if you're well and truly up to date, by November, December, January, you might be looking for a little bit of extra work. If you're getting the seeds out there now, it'll start to come in. Exactly. And the other thing, just make certain that you touch base with your clients. So once a month, ring them, see how things are going. Tim, Grant, just call me, see how things are going. Crazy world. So you have a chat. And then at the end, you say, Grant, just want to double check. Is your will or power attorney up to date? And you go, of course not. And so, listen, I'm going to send you a proposal. Let's just get that sorted. I'm worried if anything happens to you, your money's not going to stay in your family bloodline.
And it's interesting. We were looking at doing some stuff with H&R Block, who've got, I think, 500,000 or 1 million units. And they wanted to use our system, but they've gone out in Canada. They went through and they did a sample of a lot of their clients and offered them estate planning, and 93% of them your clients wanted to do estate planning. Now, we ended up going out of that because we prefer to work through accountants and financial planners than to mums and dads directly. It just doesn't suit our needs, and we'd rather be lean and mean and build traction and strategies and documentation for you guys. So we've got as I said, we've got the Advanced Healthcare Directive coming up in 2 or 3 months. We've got Enduring Guardianship, and we've also got an SMSF living benefit direction or set of nominations, so that in the event you've got incapacity, much the same as a death benefit, but you want to have this pension, being paid out a certain standard of living. So that's, again, it's another crucial document that really, the more you put in there, as you well know, Tim, and obviously is the more you can put in, the more value you can put into that pricing methodology.
Yeah, 100%. I just think for all the accountants and others listening today, this to me is the easiest way to move into doing an expanded range of services for your clients. And it truly is, when you explain it properly to your clients, it's something that they worry about, and they're so relieved when they sit in front of you guys and they sign it and it's done. That's a weight off their shoulders. And of course, you put that in your calendar system to follow up in 12 months' time. Because things always change in their situation, and they might, someone that might be in there as an executor, all of a sudden they've had a fight in the family. They don't want their sister doing that anymore. So
they've been divorced.
Divorce, there's a lot of that. Yeah.
No. Now, Khush, are you there at all? So I just want to go through your process. I know that you'll come in, you're probably like Mr. Gung-Ho at the moment. So, from a background, but you're doing quite a lot of this stuff. And what are the feedback like, and how's the process, and how are you going with it?
Yeah, I've just started about a few months ago, and currently it's just been a pretty much ad hoc. When I see clients for a review, I've sent out a few of your marketing letters, and I'm looking forward to Tim's marketing letters coming on stream through Change GPS, and that should be good. I guess the main issue I find is getting clients to be interested. COVID has definitely focused clients' mind, like the one we did last week with Tony Machado. I've been following up with him for the last over 12 months, get your wills done. And he suddenly realized he lost a few of his acquaintances and friends to COVID, and that suddenly focused his mind. I need to get something done quickly.
I know, it's funny. It's it's actually, sometimes it's a better way to do an enduring power of attorney, just in case something happens, and then do your will on top of that, because unfortunately people hate to focus in on that they're going to die, and that's one of the greatest fears of everyone is obviously the death. But it happens to us all, and the worst thing is if you die intestate, it ends up being an absolute nightmare. With
mess,
public trustee comes in and it's an absolute fortune.
The other issue that I've been finding with some of the older clients, so in the 60s and 70s, they like to go the traditional way, sit in front of a solicitor.
Yeah.
And
which
having
is okay.
to do things online.
Yeah, which I think it's not a bad idea. I mean, for some of those old ones, and unfortunately, from what we see, in fact, Tony and I are just working on a case at the moment that going to the solicitor can end up being an absolute nightmare, because what they do with their super, what they do with this, potentially they're just laying a family visions trap for the client.
Yeah, but the issue is they keep talking about it, but they never do it.
Yeah, exactly.
And then this is a client of mine who was in, I think, late 60s, and she prefers to sit in front of local solicitor, find a solicitor, and she still hasn't done it. So I'm seeing her next week, and again, I'll raise it with her. And eventually, hopefully, she'll come through the Lightyear doc system, but we'll see.
Yeah.
So those are the issues. So over the next 12 months, I want to have a more formal process for contacting clients. Like currently, as I said, I've just been doing it ad hoc, and I've done a few of them, and it's been quite successful. But I want to have a formal process using, I think, your marketing material and Tim's marketing material, and go through all my client lists as I'm doing the tax or the financial planning over the next 12 months.
So the ones that have gone through it, how have they found the process?
Oh, they found the process pretty easy. Yeah. The other thing is getting them to complete the data capture form.
Yeah.
They just never do it, You got to sit with them and hold their hand and go through it at that time. But sending it out to them.
One of the little hacks that I do is that I'm probably like you. I use the Moat quite a bit. If I can get them on a Zoom meeting, I don't show them the screen, but what I do is I go through, all the interview questions.
Yes.
So I actually go through all the interview questions and put them in while I'm discussing it with them. Just say, look, I'm typing it down, but little do they know it's actually going into the interview screen. So that's the best. I mean, if you can get to that stage of just even getting a Zoom with them, and then you don't, then the data capture is irrelevant.
Irrelevant.
You're actually building it straight from the pot. And look, I know the same is that I've seen a couple of the old ones that Tony has sent me from other legal firms. And if I had a look at that, it's like, oh no, it's all too difficult. But if I got that face-to-face, and particularly with COVID, we've now got that opportunity of going face-to-face with clients that, you can just simply complete it virtually on screen, which is the best way of doing it.
Yes, I think the process is pretty simple and easy. Once you get the clients interested, and once they are interested, it's pretty easy completing the Lightyear docs, the information on Lightyear docs, and producing the documents.
But look, I agree with you. Is that it's like anything. If you get something from an accountant or your planner, comes to an email or whatever, and says, "Can you fill this out?" It's always it goes straight to the bottom of the list.
That's right. They never do it.
If it's like, well, come on, let's do a discovery session on a Zoom meeting.
I think, I agree. That'll probably make a lot more sense, and especially now it's a lot easier with COVID when you're not seeing clients that much. Yes.
Yeah, so you can easily get on and say, okay, well, this is, let's just have a chat, discovery session. And the good thing about it is, even if you do the discovery, they don't want to go through it now. You've got all the information anyway. So when you go back 3 months, if they say, oh, yeah, I'd like to go through, you go, oh, that's okay, we've got it there. But look, I know you've done some amazing work around that. So it's great to have you on board, and your enthusiasm is around about the 80 to 90%. And I think for everyone who's watching this is absolutely crucial is that, what would happen if you had to go to hospital now? What would happen to all your businesses? And if you're in there for 6 weeks, and then what would happen if you passed on? What is those impacts on you? So forget about your clients. Go on and fix your own wills. Look at your own SMSF and go through the process of the SMSF instead.
Yep. And I'll add something to that also, guys, is that, like I was saying before from the outset, is that I just recently lost my godfather to COVID on Sunday, the Sunday that just went past. I found out that he hadn't had a will or an EPOA in place either.
Oh, God.
Now, this is going to cause a drama now,
That's going to be
at least 6 months. Yeah. And they're coming to me now to try to fix it. Well, my hands are tied, You have to go through the process now. You have to go through the process. You have to go through through the courts now. You have to, it's a nightmare.
Yeah, there won't be anything left in the state by the time that happens. Anyway, it's we're up. We've just gone a bit over time, but look, thanks.
Can I say one thing, Grant?
Sorry, yeah, go on.
I was going to say one thing that I don't think it's been covered today, but single director companies, what your system has with the enduring powers of attorney, for all the accounts out there, if you've got a single director company, unless you have a proper resolution in place that Grant and Tony have put together in their EPOA pack, your clients won't be able to continue trading their businesses. That's a nightmare because you sometimes think, the executive of your estate can jump in. They can't. So I think that's just a very big thing for everyone to be aware of as part of this process. Every single one of your clients with a single director company, we'll put some marketing together and get out for GPS members, but just to be able to get it out there and say, hey, listen, you need this, because if anything happens to you, unless you've got this resolution signed in conjunction with the EPOA, you can't move forward. I reckon that is highly critical, and no one's talking about that.
No, we've actually taken, believe it or not, Tim, to multi-director companies. So we got mum and dad. And even if you're, for example, in a reasonable sized business, just to make sure that your EP, if you can get it signed, obviously, because you need to obviously the other directors. So if you've got your EPOA in there as your alternate director, because if you and I were in business and something happened to me, you might say, well, sorry, I'm going to take control of it without me having someone in there. And of course, you're not a ne'er-do-well, but of course, there's other people who may well be ne'er-do-well. So again, these are some of the things that we end up finding out in practice, that we get feedback from you guys, and we appreciate all that feedback and just different ways of doing things, because we're all in this together, and it's really important over the next 12 months to 2 or 3 years, because it's going to be a pretty tough time, I think, for a lot of people over the next the next 10 years or so, 5 years, and we really need to have a look at the next stage is obviously going to be mental health. So let's all be on top of it and make sure we do the best for our clients. I know you've got a session tomorrow. Tim, do you just want to give it a bit of a plug before we jump off?
Yeah, well, look, it's Activate Change 2021, and it's really fully booked at the moment, so no one else can actually join. But look, we'll let everyone know for next time. But you're coming on in the afternoon to do an expanded session on me, a bit like this, but how accountants can really do the asset protection rule. And I think you're on a panel at the end, along with James Ashford from the UK, and old mate Ron Lesh, and also Bruce Coombs from Quickfee. So make certain you've got a glass of red in your hand, Grant, at about 4:15 tomorrow afternoon.
Yeah, I wouldn't be able to stump up for a Barolo or a nice 1970 Shiraz like you, but I'm sure I can find something in my cellar.
I'm sure you get something tucked away. But yeah, look, and we're going to do a special session for sole practitioners in a couple of months' time as well. We just see that there's different needs in the accounting marketplace, and again, Grant, Tony, we love what you guys are doing, and we need to have more accountants be aware of it, and we'll be continuing to try to promote as much as possible what you do, because it's great.
Okay.